Welcome to the 2020 Virtual Civil False Claims Act and Key Tam Enforcement Institute, sponsored by the ABA Criminal Justice Section. This session is entitled Loan and Grant Fraud. Before I introduce our panel, we would like to take a moment to thank our sponsor. Colin and Colapinto LLP is the supporting sponsor for the 2020 Virtual Civil False Claims Act and Key Tam Enforcement Institute. Thank you for your support. Moderating this session is Kimberly Friday. Kimberly is a partner with Osborn, Maledon in Phoenix, Arizona. Kim, you may proceed with the program.
Thanks, Courtney. And joining me on the program today are Renee Brooker, a partner at Tycko and Zavareei, Colin Huntley, Deputy Director in the Department of Justice Civil Fraud Section, Gregg Shapiro, Chief of the Affirmative Civil Enforcement Unit at the U.S. Attorney's Office in the District of Massachusetts. And Gregg also was on detail to SIGPR for part of this year, which is a Special Inspector General for Pandemic Recovery. And hopefully joining us a bit later will be Michael Vernick from Hogan Lovells, who's having some technical difficulties at the moment. Could you go to the next slide, please? So, there are dozens of different loan and grant programs that the government has started this year in response to the pandemic. And it could take us hours to really talk about them all. So today, in the interest of time, we've decided to focus on 4 programs that are likely to see heavy civil enforcement in the coming years. And that's the PPP program, the Economic Injury Disaster Loans, the Main Street Lending Program, and finally the Provider Relief Fund. At the end, if we have time, we also plan to talk about the government's historic enforcement of research grants and how that might be come into play with the pandemic grants going to the CDC and the NIH. So just for some background, if you could go to the next slide, please. The CARES Act. All of these programs we're talking about today were enacted under the CARES Act, which provided $2.6 trillion in federal loans, grants, and financial assistance. It also created the SIGPR that detail for some of this year to conduct audit investigations for certain of the CARES programs, but not all of them. The SIGPR is similar to the SIGPR for those of you who the Troubled Asset Relief Program that was enacted in the aftermath of the financial crisis in 2008. SIGTARP is still active 12 years later, and my guess is we can expect that SIGPR is going to be similarly active for a long period of time. Next slide, please. And so why don't we kick it off talking about the Paycheck Protection Program, and I'll ask Colin to give a little bit of a background to the program and talk about what we plan to see when it comes to FCA actions based on the PPP. Colin?
Thanks, Kim. Most people are familiar with PPP. There's been quite a bit of news about it, and we're going to talk about a few issues that you probably have read about and what the implications of those are for FCA enforcement. By way of background, PPP was rolled out in 2 general phases. The first was around $350 billion, the second $310 billion. The program closed in August of this year. There were approximately $100 billion in funds that remained unused. And of the total $2.6 trillion of CARES Act money, this is a pretty substantial component. It's important to conceptually, I think, differentiate between PPP loans and EIDL loans. There are certainly borrowers who have both EIDL loans, which we'll talk about in a little bit, and PPP loans. And there are some rules for the interplay on those. But generally speaking, for PPP, you're looking at a maximum loan amount of $10 million. There are about 5.2 million PPP loans that have been approved and funded. And interestingly, about 70% of all of those loans are small dollar loans, $50,000 or below. And while they make up the lion's share of all of the loans, because they are small dollar loans, they actually only account for about 12% of all of the PPP funds. So there are still quite a few very large dollar loans for borrowers who are closer to 5 or in that range of 5 to 10 million. This is a program that was rolled out really very quickly, just due to the exigencies of the COVID situation. To put things in perspective, it's helpful to think that in the prior year, 2019, SBA and its 7A program did approximately $23 billion in loans. And PPP is, generally speaking, a much larger version of the 7A program. Many of the rules are incorporated into PPP. But if you consider the fact that over a 12-month period, SBA did $23 billion in loans the prior year, and then in less than half that amount of time, they did 30 times that amount. So it's really just a huge program. The guidance has been issued through the form of several interim final rules. The first interim final rule is worth looking at specifically with regard to the use of funds and the rules that govern that. The 7A rules for use of funds are incorporated by reference, but the majority of the funds are intended to be used for payroll. And there are a number of other guidance documents that are worth checking out, some of which we'll be referring to, including some frequently asked questions that the SBA has on its website. If we go to the next slide, please. Much of the attention so far has been focused on eligibility criteria. And so when people are thinking of potential False Claims Act issues, naturally they're looking at the front end of this process where people are applying for loans in the first instance. There's a couple of things that are worth thinking about. There was a lot of attention very early on in April. You probably remember press reports about certain large restaurant chains where different franchises were getting PPP loans. There were also some hotel groups that were getting PPP loans. And there was this sort of public shaming that resulted in a number of borrowers returning funds. And there was a grace period that was afforded to people in and around May where people were encouraged to return the funds if they didn't have a true need for the funds. The phrase that's used in the PPP application document refers to good faith certification of economic uncertainty, and that the funds are necessary to support ongoing operations. Some have said that it's unclear what that means. I think it's pretty clear, but maybe I'm biased. If you look at the agency guidance, specifically FAQ 31, FAQ 46, you get a pretty good idea. And we certainly have a good sense of what does not fall into this category. So, for example, if you're a publicly traded company, you have substantial market value, you have access to capital markets, it's unlikely that you're going to be able to actually certify in good faith to this. There's other issues, too, that are in play. You have to have been in operation with employees on February 15th, 2020. There are a lot of criminal cases people have seen that have gotten quite a bit of attention where it's essentially a sham company. And so, that's a little bit different than I think what you will probably see on the civil side, where you might be dealing more with affiliation rules and things of that nature where you get into size limitations. But you also, that brings up another good point that size is obviously a factor. And I mentioned those press reports about restaurant chains, hotel chains. There are some exceptions baked in to PPP for certain businesses that are sort of assigned a NAICS code of 72, which covers restaurants and hotels. You also can't be suspended or debarred. That's pretty self-explanatory. Next slide, please. Okay, so something that has gotten a tremendous amount of press recently, I'd say daily, even up into and through today, are these loan necessity questionnaires. This gets to that first point that we flagged on the prior slide. So there are two forms that SBA has put out, the 3509, the 3510. And the purpose of these forms is to collect information from borrowers for those who have received loans in excess of $2 million. That's an important threshold we're going to talk about in a little bit when we get into a discussion of defenses. But for borrowers of $2 million or higher, this form is intended to collect some basic financial information for purposes of assessing your certification that the funds were necessary. You'll see here, one of the bullets says extensive and detailed questions. It's a 9-page form. So, there's probably reasonable disagreement about how extensive it is. I think I would make the argument that given that the upside is potentially 100% loan forgiveness, a 9-pager doesn't seem that unreasonable, but That's my view. So that's another issue to keep an eye on. And this is a very fluid issue. I mean, there's a number of things in the context of PPP where you're dealing with a very fluid situation and rules that are getting refined in real time. A really good example of that would be borrower eligibility criteria for people who have prior felonies. You know, that did get refined a bit over the first 4 to 6 weeks of the program after it was rolled out. So I think this is an area where people should keep a close eye on things in terms of what ends up being required with regard to these two forms.
Colin, can I ask you, so do you take these loan necessity questionnaires to mean that if SBA sees an answer it doesn't like on these questionnaires, it's going to go back retroactively and say the borrower didn't have a good faith basis for attesting to the necessity of the loan back when it got the loan?
You know, I'm not sure. I certainly can't speak for SBA in terms of what SBA intends to do with the information, but SBA has said repeatedly, and I think very clearly, that they do intend to audit all loans of $2 million or more. So to the extent that there are questions and certifications on the front end at the application phase that go to this very issue, I don't think it's too much of a surprise that they're evaluating this issue along with all of the other issues and certifications that one would see, you know, on the application form itself. I do think that, you know, we'll talk about defenses in a little bit, but there's always this tension in the context of a certification where defendants will say, look, obviously with the benefit of perfect hindsight, we might view things differently. But for purposes of FCA liability, we often, in any case, whether it's a traditional 7A case from 3 years ago, long before PPP or now, are certainly going to look at the facts and circumstances surrounding when those certifications were made on the front end. So I think it's a very fact-specific question that's going to vary quite a bit from case to case. Next slide, please. So for purposes of loan forgiveness, I think it's important to keep in mind that we are just on the very front end of the forgiveness phase. So there are many, many borrowers, certainly the majority of borrowers, who have not yet sought loan forgiveness. So this is something that's also very fluid. There is been a little bit of change with regard to the rules on how much needs to be spent for payroll expenses. So back in April, it was 75%. Over the summer, there was the Paycheck Protection Flexibility Act that lowered that to 60%. That's an issue to sort of keep a close eye on. But it's pretty clear that regardless of that percentage, there are very clear and consistent limitations regarding the use of funds, which really haven't changed from the first interim final rule till now. And I think when you get to the forgiveness stage, that's when things get a little bit more interesting with regard to how funds were used, whether they were for permissible uses, because you could have a borrower who is unquestionably eligible to participate, gets the funds in an appropriate amount consistent with whatever their payroll records would be to justify it, and then nonetheless doesn't use those proceeds for the permissible uses. So that would also create some FCA liability, and on that phase at the back end, there's certifications as well that go to the use of the funds. So you have those certifications on the front end, certifications on the back end of forgiveness, and there's also some damages issues we'll talk about in a little bit, depending on where you are in the process from the beginning to the end forgiveness stage.
Thanks, Colin. Let's go to the next slide. And before we really delve into some of the likely defenses in these cases, I'd like you, Colin, to talk about what is the civil FCA PPP case going to look like? Because so far, I think all we've really seen are criminal cases that are real low-hanging fruit. You know, the company doesn't exist, or there are employees that are made up, and it's just clear criminal bank fraud, wire fraud. To me, there's a question as to what exactly are going to be the civil cases that, for whatever reason, you know, you're not seeing the appropriate scienter to rise it up to a criminal violation, but it's something the government nonetheless thinks that it can pursue.
That's a good question, and I'm glad you mentioned, you know, that there are these criminal cases out there. They tend to be relatively crude fraud schemes, in my view. This is essentially basic bank fraud. You're making up a company that doesn't exist, lying about employee headcount, providing fake documents to banks. I think on the civil side, we do quite a bit of small business contracting fraud, and we do quite a bit of investigative work in the 7A context traditionally. So some of the issues that we will see are not new issues. I mean, they may be arising in the context of a new program, but even the new program bears so many resemblances to the 7A program that the types of cases we would see in that context are very good indicator of what I think we would see PPP. There's going to be plenty of cases that deal with eligibility issues, and whether it's a company that was suspended or debarred or had a majority owner who was suspended or debarred at the time that they applied, or they exceed the size limitations, or they fail to disclose certain affiliations. You know, aside from the restaurants and hotels that fall within NAICS Code 72, everyone else is largely dealing with the same SBA affiliation rules you would do long before PPP came around. So issues we're familiar with, we're going to see again just in a new context.
Could I just add briefly to that? I think there may be some issues with the intermediaries, the banks, which have, under the terms of the program, have very little responsibility, but I don't think it's zero responsibility. And to the extent that a bank is knowingly lending, or not really a loan here, it's what it's called, but in fact, for most people, it's a grant, but is giving out this money or enabling this money to go out, knowing that the borrower or the recipient of the money does not qualify for some reason, or that the borrower is getting more money than they qualify for. It could create some interesting issues in terms of the liability of those intermediaries in the program.
Yeah, that's a great point. I actually want you to hold that thought, because we're going to come to that in a bit, and I want to come back and ask you about that. But in the meantime, why don't we focus on, I think, Colin, you mentioned that really we're dealing with two buckets here. There are loans less than $2 million, which are the majority of loans, but not the majority of money in the program. And then loans above $2 million, which are far and away the largest amount of money to the program. And you all may have seen a Washington Post article earlier this week analyzing the PPP loans that noted that more than half of all of the PPP loans went to just 5% of the recipients, including over 600 borrowers that received the maximum amount of $10 million. So given all of that, I think there's a question as to how much the department is going to be enforcing these loans that are less than $2 million. Not only do you not have a good financial hook to base, the expenditure of resources on, but in my view, you also have these other potential defenses that apply to these loans. I think it's been widely discussed, the safe harbor. It's not technically a safe harbor. We're calling it a safe harbor that applies to these loans for less than $2 million. The safe harbor applies to audits, enforcement, and criminal referrals on the SBA side. It does not apply to FCA liability. But there's a question, as I said, as to whether the government is really going to have an appetite for these loans. And then we also have a presumption of good faith that's given to the borrower certification of necessity when the loan is less than $2 million. And I think the presumption suggests that that certification is not material as it applies to borrowers who are borrowing less than $2 million. If it were material, the government wouldn't apply a presumption of good faith. I'm curious what you think about that, Gregg.
I have to say I'm not sure that a presumption of good faith really works. If someone is knowingly lying, it doesn't. I think the presumption goes away, and I don't really see that the protection from audits is a protection from lying. So I think the bigger issue is that these loans of less than $2 million is it going to be worth the candle for us to do that? I mean, there's tens of thousands of these loans, and so. There, just as a practical matter, I think it's going to be very difficult for DOJ to be looking at a lot of really small loans where it's not a really obvious fraud the way we've seen in some of the cases that Colin talked about already.
Yeah, I think that makes sense. And let me bring Renee in here for the relator point of view. Renee, maybe you can just give us a thumbs up or thumbs down. Are you going to be taking on cases where the amount of the loan is less than $2 million?
Well, I think it's hard to answer that by just focusing on the dollars. I think that we are seeing cases that are coming in, and we're still evaluating all the different components that Colin and Gregg just laid out. I think it is important to go back to the point that you raised, Kim, which is in looking at the Paycheck Protection Program, you have to look at the dollars and the number and volume of loans that have gone out. There were 5 million loans at issue, but 600 involved large companies that received the maximum amount of loans. And those were large companies, including chains, some of them publicly traded. So I think that those are potentially going to be a focus. There were only, out of the total universe of loans that went out, only 28% were in amounts less than $150,000. So, and 522 billion went to large businesses. That's an incredible, volume of dollars. And so I think that you have to look at some of these particular loans that may have been backed by private equity chains and companies. And so I think it remains to be seen. And I think it's going to depend, as I always do, on whistleblowers who have inside knowledge stepping up and stepping forward. And I think that there are certainly various categories of potential fraud that you could look at, and really just looking at Colin's breakdown of how he evaluated the different components of the program. There's the potential for fraud in the eligibility, false statements when the companies applied for the loans, false statements in terms of the loan application itself and whether or not the company was eligible, are two potentially different areas of fraud. Also, fraudulent use of the money. There are certain requirements for how the money needed to be used. And I think it's important to keep in mind that for this particular program, the PPP program, the main overall purpose was to allow primarily small businesses to continue to be able to pay their employees. So a large part of the purpose was not just to fund the small business, which we'll talk about a little bit of a different program, was the EIDL program. Here, the purpose was also to continue to have workers continue to have employment and continue to have the companies be able to make payroll. So I think there's several buckets, including the loan forgiveness component. You could also have an eligible institution or small business, rather, apply for a loan. They could have been eligible, but they may have, made false representations in the intent for what they were going to use the loan for. And at the end of the day, if they apply for loan forgiveness and do not meet those qualifications, they may have been eligible for the loan in the first place, but they may have a potentially reverse false claim issue down the road, or in just an affirmative false claim if they are applying for loan forgiveness and do not qualify. So I think it's kind of premature. I mean, looking back at the financial crisis and all the different components of cases that we had several different initiatives. And during that time, it really actually took a significant period of time to wait and see. I do think that there are some frauds that the government should not wait and see on in terms of these programs that we're talking about today, but in others, it may take, as Colin said, these loans, some of them have not become pay doable, and some of them, the loan forgiveness aspects have not yet kicked in. So it may not be that the government is going to be inundated with reports of fraud, right up front. But I do think eventually, just like with all the other areas of fraud, and just very parallel to the financial crisis, I think that over time you will see some fraud patterns emerge. And I think that you will have different offices of the, different U.S. attorneys' offices have different focuses and see different things in their district. So I think it's too premature to tell, I guess, is the short answer, Kim.
Well, fair enough. Why don't we go to the next slide? Because I think this is where most of the activity is going to center on, and that's the loans greater than $2 million. As Colin mentioned, every loan above $2 million is going to be reviewed by the SBA. Who knows how long that's going to take. But there is an ability for the SBA to simply ask for a refund of the loan to avoid administrative enforcement or a referral by the SBA to DOJ. And I think I'd be curious, Colin, perhaps your perspective on what you do with a defendant who, once it learns of an investigation, simply refunds the money back. At that point, what's the government's real motivation to move forward, and what does the case even look like?
Well, I think that there's a little bit of a misnomer among some folks I've spoken to who've said that, well, if the money just gets returned, if you get caught with your hand in the cookie jar and you drop the cookie, we're all good. It's really not quite that simple. There are other ways in which the government is harmed other than the potential loan forgiveness or federal guarantee on that loan. There are processing fees, and those processing fees escalate with regard to the loan amounts. So you could have a situation where lender extends those funds to the borrower, upon notice of an investigation, quickly returns the funds, but the SBA may still be out some processing fees. Those can add up. You obviously have penalties under the FCA. The other thing that I would flag, too, is while it may not help relator and acquitam if the proceeds are returned in the pool from which a relator share could be drawn, under that scenario, at DOJ we have a lot of other tools in our toolkit, one of which is FIREA. And FIREA also addresses false statements to SBA. So there are heftier penalties under FIREA that could potentially be in play depending on the facts and circumstances of a case. And so it's not quite as simple as a defendant can get a mulligan by just returning the funds.
But, sure. I mean,
as a practical matter, though, if we have, let's say we're looking at 10 cases of fraud and they're all more or less the same, and 2 people the day after they get a subpoena return the money and the other 8 don't, then chances are we're going to focus more on the other 8. It's just reality.
Yeah, I think that's right, Gregg. I mean, I think processing fees and penalties only take you so far. And this dovetails maybe into the next issue, which is, when does the government actually suffer damages in these cases, and when do federal funds become involved? Colin, do you want to talk about that a little bit? Because I think a lot of people maybe don't understand exactly the point at which government money comes into play.
Yeah, SBA has some direct lending programs. PPP is not one of them. So SBA works with the lenders. The lenders are doing the application process directly with the borrower. The lenders have to submit information to SBA at several different junctures during this whole process. Shortly after the application is submitted, there's some information that's provided to SBA. When you get further down the road toward loan forgiveness, there's other information that the lender provides to SBA. But fundamentally, SBA is not directly giving SBA money to the borrower when the borrower gets that PPP loan. So there are some interesting issues that arise. They're no different, though, than what we've seen in, for example, the 7A context and some other loan contexts outside of SBA for a handful of years now, including cases that arose out of the prior financial crisis. So these aren't new issues. Again, I think we'll see some old issues in a new context. But the damages question is one that's going to present in probably a good number of cases.
And as Colin mentioned, there's also FIREA. So even if the loan isn't owed yet, and we'll get to this when we talk about Main Street, but even if the loan isn't owed yet and there was fraud, and so at this point there's no damage to the government because the loan's still outstanding, we could still potentially put together a FIREA case because there was fraud, and FIREA provides for pretty significant penalties.
That's a good point. I think it's $1 million, right, is the maximum penalty under FIREA. I don't know if that's changed due to inflation. I mean, if you're not basing it on loss or gain, which you wouldn't be able to do here. Maybe.
Fair enough. Anyways, it's just it's just another avenue to think about if we've got a case where we know there was pretty blatant fraud. It seems extremely unlikely that the borrower is going to return the money, but the borrower doesn't have an obligation quite yet to return the money.
Yeah, fair enough. And I'll just briefly mention there are scienter defenses for borrowers here as well because of the shifting nature of the SBA guidance that has gone through various rounds of modifications and elaboration as the year has gone on. And then there's the question itself as to what extent even that sub-regulatory guidance can be relied on by the department in bringing cases. I don't want to spend the entire time talking about PPP, so why don't we go to the next slide?
Just on the sub-regulatory guidance point, I think that's a good point. And for us, I think we're going to focus on what were the actual certifications, which may have incorporated some of the sub-regulatory guidance depending on when those certifications were made.
Yeah, thanks, Gregg. That's a good point. And can we go actually back a slide? Because I did want to pick up this point you raised, Gregg, about possibly seeing liability for lenders. We have the top 15 lenders who issued over $150 billion in more than 1.6 million of loans. It's a lot of money. And the PPP is very forgiving in how it treats lenders, presumably because it wants to encourage the loans. But I am curious what you think the limit to lender reliance could be. In your view, if the lender has actual knowledge that the borrower is not eligible, is it unable to rely on the borrower certifications?
I don't have a definitive view, and I'm not sure the department does. Maybe Colin does, but it's certainly something that if I saw evidence that a lender knew over and over again that it was giving money to borrowers who were ineligible, maybe even I saw that borrowers were giving kickbacks to loan officers or something. I mean, I'd look pretty hard and try to come up with some way to bring a case, notwithstanding the first bullet point you've got there about the ability of lenders to rely on borrower certifications.
What do you think?
I agree with Gregg, and I think he made a really good point earlier when he said, the fact that the bar may be low doesn't mean that there's no bar at all. It's going to be very fact specific, but I don't think that the hold harmless provisions that you see foreclose any and all potential FCI liability. I think that we will likely see fact patterns where, that those hold harmless provisions don't provide protection for a lender.
Yeah, I think this is definitely an area to pay attention to moving forward. Let's go to the next slide. Before we leave PPP, I am curious, what you think, Renee, about this notion about there being a public disclosure bar for relators in these cases, because the SBA has now published all of the information about borrower loan amounts and identities. And it seems like, the defendants might have a good argument that someone who is coming in off the street and is just doing a data analysis and saying, based on my review of a company's public filings, perhaps, or their financial statements, they didn't need this loan and they got this loan. Are those types of cases going to be barred by the public disclosure bar?
I mean, I hate to say it depends, but it always depends. But I do think that there's a lot of data that's out there and there's a lot of dollars that are out there, but the actual fraud schemes of the individual either lending institutions that are, if there's an allegation against one of these financial institutions or against a borrower, those specific facts underlying that fraud scheme, should one be brought by a whistleblower, are not disclosed publicly. So I think, as always with public disclosures, the devil's in the details. It depends on what circuit you're in. But, at the end of the day, if you have a whistleblower who has actual knowledge of the particular fraud scheme, then you could always rely upon being an original source as well. In terms of relators coming forward with complex data analysis, I think, that remains to be seen, and it's really going to, be dependent, of course, on, what it is they've analyzed, what type of data they've analyzed, what new information they may be bringing to the government. I've been involved in both inside DOJ and outside DOJ with relators who have, some sort of high level, maybe not inside knowledge, but have done a really sophisticated analysis, and they are very useful to the government and considered, a valid whistleblower, whether under an SEC program or under FIREA or under the False Claims Act. So I think that those are absolutely not automatically barred. I really just think it, depends on the level of detail of their analysis and how impressed the government is with their analysis and whether they find it unique and useful in a way that they would not, the government would not have been able to run that analysis themselves. So I still think that it's a really wide open field, and I think certainly wearing my former DOJ hat, I would have wanted to encourage people with that sort of level of detail, level of knowledge to come forward and to provide that information to the government and let the chips fall where they may once they've made that disclosure.
Okay, thank you. Why don't we move to the next slide? And Renee, can you just talk briefly about the EIDL loans?
Yeah, I will. And I never called them EIDL loans, but you and Colin are, so I'll use that term now if I can remember.
I notoriously pronounce things wrong, so don't defend me.
If Colin's using it, then it's all the rage. Yes, the EIDL or the EIDL program is a little bit different than the PPP program, and its overarching goal is different. Again, under the PPP program, the focus is under all these programs, the focus is on small businesses, but there is more of a focus on ensuring that small businesses can continue to pay their employees, keep their employees on the payroll. It's intended to benefit more directly, not just the small business, but employees as well by allowing them to keep their jobs. The EIDL program is not an outgrowth of the CARES Act. It was in existence for a number of years and has been used for, it's a disaster assistance program. As a result, in March, I think it was on March 13th, the president declared a national disaster based on the pandemic, COVID-19, and as a result, amended the EIDL program to apply to pandemic type of relief. So it was really an existing SBA program administered by the SBA that was extended as a result of COVID. So it's got a little bit more history than some of these other programs, and a little bit, SBA has a little bit more experience with that program, although certainly not in the sheer volume of aid that was, the EIDL program was funded significantly more than it had been in the past. It is intended for nonprofits and small businesses to obtain loans and advances. The advances are a maximum of $10,000. The CARES Act, in amending the EIDL program, gave a lot more leeway to applicants. So personal guarantees that are required under the normal EIDL program were waived. Businesses do have to have been in operation prior to January of this year, of 2020, to receive a loan. And other, traditional requirements to obtain an EIDL loan were also not imposed during this round of the application. So if you, in the past, you had to be unable to get credit elsewhere, that was not one of the requirements of this program. So Congress, appropriated billions of dollars. You had to show that you had a substantial economic injury in order to receive this. And the whole purpose of the EIDL program in times of disaster, including the current COVID disaster, is that you are trying to encourage small businesses to stay afloat. Just literally help them to keep their head above water so that, restaurants, you think about all kinds of small businesses that exist out there that are not massive companies or chains and have a kitty of reserve. These are really intended so that businesses can pay their rent, also pay their employees, pay their expenses, keep their doors open, even if they don't have any customers. It's really intended to be it's almost like a bridge loan between a disaster to get you to the non-disaster phase. And so that was the purpose of them. They were administered by the SBA, but the SBA contracted out this program because there's no way the SBA could have all of its employees. Probably all employees at the SBA could not have stopped whatever work they were doing and administered this program. So there are two sources of potential false claims or false certifications. It is in the applications from small businesses or fake small businesses in applying, and there's also the government contractors that are administering the loan and the advance program. The advances are really nothing more than grants. They're pretty much free money. They're very small amounts, and there were $20 billion in EIDL advances or grants that were provided. So, I mean, that's a really sort of high level summary of the EIDL program, and I'm sure that we'll see, just like with the PPP, we'll see potentially, we'll potentially see false claims and false certifications in that space as well.
Thanks, Renee. Yeah, and I'm going to go ahead and move to the Main Street Lending Program just because I'm a little conscious of time. But it is worth noting that there are widespread reports of fraud in the EIDL program, and the SBA IG has already issued 2 reports discussing fraud in the program, and those are included in your materials for this panel. So why don't we skip ahead a couple slides to the one more. Thanks. And Gregg, why don't you walk us through the Main Street Lending Program? Oh, I think you're on mute, Gregg. Sorry.
I apologize. So Main Street's designed for slightly bigger businesses, although you can get a PPP loan and a Main Street loan. There's no prohibition on getting both. But it's designed also for companies that are not so big that they'd have access to the public markets. And so these are companies that theoretically don't had a viable business before the pandemic started, had their business crash for reasons related to the pandemic, and are likely to see their business revive after the pandemic subsides, but are not so big that they can just go to the public markets and get a bond to tide them over. So, and the way it's structured is that the Fed and the Treasury both contribute to what's called to a special purpose vehicle, and then the special purpose vehicle will buy loans from eligible lenders, and it will buy 95% of those loans, and the lenders will retain 5% of the loan and 5% of the risk. So the idea is the lender does have some skin in the game, or unlike the PPP where the lender has virtually no skin in the game. So the big difference between probably the biggest difference between Main Street and PPP and also the EIDL grants is that you have to pay the money back. And because you have to pay the money back, and there's one other big difference is that I'm not sure if these rules apply, but there are also rules on compensation and stock buybacks, et cetera. So in terms of compensation for highly paid executives who make, I think it's on another slide, but we'll get to it, but who make over about $450,000, you basically can't give them a raise during the term of the loan. And if they make over $3 million, they're actually probably going to get less money. Their compensation has to be reduced during the term of the loan. So, and then you also cannot do any dividends, and you can't do any stock buybacks. So what's happened here is that since you actually have to pay the money back, it's not free money from the government, and there are restrictions on how you can pay. You can't just spend the money on your executives. The program has proved not to be nearly as popular as maybe Congress thought it would be. So Congress intended that it would create up to $600 billion in loans. And as you note at the bottom of this slide, as of the end of October, only about 400 loans have been issued for a total of less than $4 billion. And now the program is supposed to end at the end of this month. I think there was a lot of talk in the news and on Capitol Hill in the last week about whether Treasury would agree to keep backstopping the program into next year, and Treasury has not done that. So it's likely that the program will wind down, having spent far less than Congress had intended in the first place. Maybe go to the next slide. In this case, I think there will be cases. Well, I don't know if there will be cases, but the borrower certifications will be crucial to to any case against a borrower. And one of the big things is this last bullet point in terms of what type of business a borrower can be. As with PPP, it has to be a business. So if it's not a business, that's an easy case. But it also can't be a certain type of business. And one of those types of businesses is it can't be an investment business. It can't be a private equity firm. It can't be a hedge fund. While it might be a portfolio company of a private equity company, there are affiliation rules that would suggest that for any decent-sized private equity company, none of their portfolio companies would qualify. So I think that may be where the rubber meets the road for some of the cases that we have going forward. It's notable that there are not too many restrictions on how you use the loan proceeds. And is that on the next slide? Sorry, this is a difficult format for me. But well, here, so unlike PPP, you don't have to spend the money on your employees. All you have to do is make, quote, commercially reasonable efforts to retain your employees, and that's a pretty fuzzy standard. There's none of this, you have to spend 60% of the money on your employees, et cetera. And there are limits under certain types of Main Street loans. You can't use them to refinance debt, but on other types of Main Street loans, you can use them to refinance debt. Maybe, I'm not sure this is in the slides, but one of the important aspects of the program is that the money is not due back immediately. I think it's a 5-year term, and for the first 2 years, you don't have to repay any principal, and then interest isn't owed for the first year, and then is owed only on a limited basis for the next few years, and then there's a balloon payment during the last year. So we have the same problem that we talked about earlier, where no money at this point, no money is due back on any of these loans. So even if there was blatant fraud in the process of getting the loan, where's the civil case? Because there's no loss to the government yet. There's no obligation that has become realized. And yes, FIREA is something we've thought about as an alternative, but as Kim points out, FIREA has it's a limited potential remedy, especially for a decent sized loan. Perhaps go to the next slide. I think we talked about all these compensation limits. Sorry, I think I said 450,000, so it's 425,000. So basically, for these high-paid executives, they're not going to get any raises, and for the really high-paid ones, they may get a salary deduction during the term of the loan, which makes it very unattractive. Next slide. Next slide. This is just a general description of the size of companies involved here. Again, the notion is, again, companies that don't have access to the public markets. And the notion is also that the money is supposed to go to U.S.-based companies and is supposed to help them, and is not supposed to just be sent to South America as soon as the money is paid out by the bank. Next slide. The lender case, as with PPP, the lender bar is low. The lender certifications are limited. The lender is entitled to rely extensively on what the borrower says. So, for example, in terms of the status of the lender has to confirm that the borrower was a business as of, I believe, March 13th of 2020, but it can rely on the borrower's statement that the borrower is not an ineligible business, which may raise questions about, well, what if the lender actually knows that the borrower is an ineligible business? Is it still entitled to rely on that certification? And the lender also can rely on the borrower's financial statements in terms of figuring out if the borrower qualifies under the EBITDA ratios that are set forth in the Main Street lending program terms. So I think these will be the more interesting cases if there are any. But the program was designed to encourage lenders to give out money to eligible businesses, and as a result, there are few requirements for lenders here.
Gregg. And so we have about 10 minutes left in the program. I've been keeping an eye on the questions tab. I don't see any questions. If you have questions, please type them in and we'll make sure to get to them. We, want this to be useful to you and to be answering the questions that you have about these programs. But in the meantime, why don't we move on to the next slide and the one after that and talk a little bit about the Provider Relief Fund. Colin, can you give that background?
Sure. There's a couple of different channels of relief funds that are available in the healthcare space. So I want to just first let you know that we're not necessarily going to address right now accelerated payments and advance payments. Accelerated payments for Part A providers, advance payments for Part B providers. These are set up to help healthcare providers when there's a major disruption in claim submission or claim processing. These programs were expanded in March of 2020 to allow more providers to participate. That's separate and distinct from provider relief funds. Gregg also flagged an important point back in talking about the Main Street programs that you can have an entity that participates in multiple programs. So one question that I've heard from time to time is what happens if someone is getting provider relief funds and a PPP loan? There's nothing inherently wrong or suspect in participating in two programs. There are ways in which provider relief funds, I suppose, hypothetically could affect the degree to which you are or are not experiencing economic uncertainty. So there are ways that one program could bear on the other, but it's important to keep in mind they're separate programs. It is possible to participate in both, and if you are, you just have to be mindful of the different rules and conditions and the different certifications that you're making in one program versus another. You can see here there's more than 100 billion, well more than that. It's more like 175 billion that was made available for healthcare providers, really to help offset the costs of COVID-related expenses or lost revenues attributable to COVID. And that's construed rather broadly by HHS, and I think it's important to point that out. If we could go to the next slide. Right at the beginning here, we mentioned that there are these attestations confirming receipt of funds and the agreement to the terms and conditions. There's also a mechanism by which someone who receives funds and fails to return those funds within a defined time period, I think it's 90 days, are deemed to be accepting all of those terms and conditions. So that is certainly an interesting issue to keep an eye on. Also, there are some mandatory reporting requirements with regard to the use of funds. So this is a similar theme that you're seeing run across several of these different programs with regard to the restrictions on how funds can be used and the representations that need to be made by a borrower, or in this case, a recipient of the funds, as to how those funds were used. The very last point on the slide references the potential for intentional misrepresentation of revenues or expenses. I would be remiss if I didn't point out that if I had all editorial control, I would have changed intentional to maybe knowingly. But I'm biased. You can tell Defense Counsel put that bullet in. I do think that anytime you're dealing with a situation where you're going to have to be reporting data with regard to revenues and expenses, there's always a possibility that you could have some issues that grow out of that if there are problems with the truthfulness, completeness, or accuracy of that information.
Thanks, Colin. Why don't we take some of the defenses here kind of one by one? And, you mentioned the electronic attestations. So taking a step back, there is a portion of this funding that was just sent automatically to Medicare providers without them asking for it or even really knowing that they were getting it. And then these providers were given 45 days to fill out an electronic attestation to certify compliance and understanding with all the terms and conditions of the program. You mentioned that, if a provider does not submit that attestation, but nonetheless keeps the money, the agency is going to be deeming them to have agreed to submit to the program terms and conditions. But I wonder, what does that look like in terms of an actual FCA case? It's not really an implied certification. Is it going to be really more of a reverse false claim for holding on to money you're not entitled to?
I do think that there's a couple of different ways that you could frame the issue, and it may depend on what the nature of the problem is. Like if it's an issue with regard to use of funds, that may bear on how you would frame the issue. But I think a reverse FCA framework lends itself to this when you're dealing with this issue of obtaining the funds and holding on to them, even though you are knowingly violating some of the requirements of having those funds.
Mm-hmm. And why don't we take a detour really quick, because I want to make sure we do get to questions people ask. We have one question talking about the research funding context. We haven't gotten there yet in the slides, but probably won't get there. So Colin or Gregg, could you comment on the most likely FCA issues to arise with NIH research grants versus grants to support development or evaluation of lab tests for clinical use? That's a little bit broad, but taking a step back, we know that there are billions of dollars that have been given to NIH for issuing grants to all sorts of companies to both develop COVID tests and to develop vaccines. What types of FCA issues do you think are going to arise there? Are they any different from sort of the standard issues we see in grant cases? Colin, or Gregg, go ahead.
Oh, well, I think if someone puts in a good faith effort to develop a COVID treatment or a lab test with government money and it doesn't work out, as long as they can show that it was a good faith effort, it seems unlikely that there'd be a case. But I can also imagine circumstances where people see all this money going out the door and saying, "Oh, I'll develop a test," and then they don't really put any effort into actually doing it. So I don't think those cases have happened yet, but I could see them happening, and I could see the same types of temptations that are involved with PPP, just on a bigger scale, where people see free money, claim to have a business, don't really have a business, and just take the money and run.
Do you think, Gregg, and I pose this to you because the District of Massachusetts is famous for going after pharmaceutical companies. There are, a large number of pharmaceutical companies that have gotten grants to work on vaccines, grants to work on different COVID testing. Is that something your office is going to be, really interested in?
I doubt it, frankly, that we'll be going after, significant pharmaceutical companies in this space, because I would imagine that any publicly traded or even, private equity-backed pharmaceutical company that takes a grant from the government to work on COVID stuff is going to try as best it can to develop it. It may not work out, but I really doubt that they're going to be stealing the money in the way that you see in some of these PPP fraud cases.
Thanks. And we have one other question. So, how liability shields might impact FCA enforcement for any of these programs? Admittedly, might be a premature question.
Seems premature to me.
Well, I guess, it depends where maybe there are going to be state liability statutes. I don't think we'll see any sort of federal liability shield, although I'm curious if you all think differently. Colin, Gregg?
I think our job is not to prognosticate about what Congress might do.
Yeah, fair enough. All right. Well, I'm wondering if any of you have any sort of last thoughts to sum up what we've been talking about today. Maybe, Renee, you can talk a little bit about what you're seeing on the relator side and what cases you're actually finding most attractive to pursue. Because I think, DOJ can have its enforcement priorities and they're well and good, but at the end of the day, a lot of DOJ's enforcement is actually directed by relators in the cases that they file. Colin and Gregg might disagree with me on that one, but I know you'll agree with me, Renee.
Well, I would have agreed even when I was at DOJ, sitting in the seat of the DOJ prosecutor, because, the vast majority of False Claims Act cases are brought by whistleblowers, and just like every other space, whether it's big pharma or financial fraud, or procurement fraud, you're going to see trends that get begun based on the False Claims Act, KETAM cases that get filed by relators. Just like in the most recent example is in the electronic health record space, that first big settlement was based on a whistleblower case, and now you're seeing a big interest and focus by both the whistleblower bar as well as the Department of Justice. I mean, from my perspective, the basic False Claims Act theories are ones that you can apply in any context where you have government funds at stake. And here, I think there are some concerns that many of us on the plaintiff side, whether we're on the DOJ side or the private plaintiff side, focus on, not too different, frankly, than what happened right after the financial crisis, where a lot of money based on good intentions and in good faith by the government had to be expended really quickly in order to help Americans, both small businesses and individuals. And so money went out very quickly, much to everyone's chagrin at the Department of Justice. We would rather have seen the money more closely scrutinized before grants were provided or loans were provided. But that is, that's what the government was charged with, the responsibility of getting relief to people as quickly as possible and figuring out later, how the funds may or may not have been misspent. It's obviously no taxpayer thinks that is an ideal way to administer government, precious taxpayer funds. But I think that if we just go back to our tried and true theories under the False Claims Act and we look at false statements, false certifications, I think that they can be applied in this context no differently than they have in all of the other contexts, whether you have a grant or a loan or a contract. And I think that, these theories will play out. They'll be a little bit more challenging, the cases for the government and for the plaintiff side, because money was spent quickly. And so that'll be a bigger challenge for us. But I think at the end of the day, the defendants are required, whoever they are, whether they're financial institutions, healthcare providers, big companies, small businesses, they are obligated to turn square corners with the government, and we should hold them to that. And if they were not operating with integrity in taking the funds, I think we should go after them with all of the tools in our toolkit. And I see this as really no different, except maybe a little bit more challenging for lawyers than any other, past crisis or past fraud that we've seen.
Thanks, Renee. And we'll leave it there. That's all the time we have. Before we leave, I want to thank you for joining us today, and thank you, the panelists, for an informative discussion. On behalf of the American Bar Association and the ABA Criminal Justice Section, I'm Kimberly Friday, thanking you all for joining us. Please join us in 10 minutes at 3:45 p.m. Eastern for our last session, Ethical Issues in KETAM Investigations.
Thanks, Kim.